Well, the President's legal counsel has since welcomed the ruling, saying President Ramaphosa feels vindicated. Reporter Lindsay Dentlinger has also been following the case. She joins us now from Cape Town. Hi, Lindsay. So, the President obviously welcoming today's ruling. I wonder what Busisiwe Mkhwebane is saying. He, of course, while he was DA leader, kicked off all of this with his question in Parliament.
He did indeed, Sally, but interestingly enough today, the DA referring all comment and queries to Busisiwe Mkhwebane themselves. The DA, now DA leader, John Steenhuisen, saying that at the time when he was the chief whip, he warned Busisiwe Mkhwebane not to ask this question because, as we now know, that originally what Busisiwe Mkhwebane was trying to get at was whether the president's son had received money from Bosasa. And then, of course, a few days later, the president then wrote to the speaker and said they'd all gotten it wrong and they'd all misinterpreted what was being questioned and the information that was put before Parliament. And that, in fact, what we were trying to get at was that the money had been paid to CR17 campaign. But Busisiwe Mkhwebane says even though he might have gotten the facts wrong on the day, he doesn't regret asking that question. He says it would have been a dereliction of duty if he didn't act on information that was given to him by a whistleblower, even though his chief whip now, a former chief whip now, says that he warned Busisiwe Mkhwebane against asking that question. Mkhwebane, by his recollection, says he doesn't recall that and he has no regrets at posing that question. And he said that's essentially now water under the bridge, Sally, and that the matter is essentially not over. It now opens up many other questions about what we do about internal party funding for personal campaigns, and that's also the feeling of the Amabungani Centre for Journalism, which the ConCourt now has given the right to return to the High Court to challenge those issues, because as we know right now the Party Political Funding Act is not quite explicit as to what happens, what should happen, and whether the funding into personal political campaigns should be regulated. But this is what Busisiwe Mkhwebane had to say following that Constitutional Court judgment this morning.
Given that Bosasa was involved in state capture, what was the benefit to Bosasa? I happen to agree with the Chief Justice Mkhwebane when he says, when you receive a donation for campaigning, there is a personal benefit in that regard. Now, we know that as a fact. The question then still maintains, what was the ultimate benefit to Bosasa in exchange of this donation?
And I suppose really that hints at what you mentioned around the Amabungani part of today's Constitutional Court judgment, that the issue needs to go back to the High Court, that the High Court should have made a decision around the fact that those donation records into his campaign are still sealed. So that's still got to play out and will probably take some time. I'm wondering how the Public Protector is feeling. This is yet another blow for her in court. There are impeachment proceedings underway at the moment that she's trying to fight. This can't be a good day for her.
Well, Sally, firstly, as far as those that impeachment process is still to unfold, we know that there's a committee established, but when exactly they'll start doing their work is still unknown. But we should also know that the committee can now only really deal with cases that have already been put before it in that motion that was originally tabled that's led to these impeachment processes. So whatever adverse findings come after that can't really be added to that pile when they eventually get to conducting that inquiry. But that's neither here nor there at this time. What we should also note from today's judgment is the kind of findings or recommendations that the Public Protector made in ordering the Speaker to take certain actions and trying to tell the Speaker how to do her job and how she should be keeping house in Parliament. And the Court today finding that the Public Protector couldn't tell the Speaker, for example, how to change the rules of question and answer sessions where this whole matter got vented ventilated in the first place, and also couldn't prescribe to the police and the prosecution authorities how to do their job in terms of this matter, and also lambasting Parliament for, in her view, not taking the President to task at the time in terms of whether he should have disclosed these donations to Parliament as part of Parliament's Executive Code of Ethics. But the Public Protector's Office saying that they take today's judgment as a lesson, that there are always going to be debates and varying legal views, and also taking issue with the fact that the court had said that she had used her own words, her own interpretation of what these codes of conduct mean, and that in fact pointed out today earlier to our anchor Clement Manyetela that in fact the court might not have been aware that she was weighing up this remedial action against President Cyril Ramaphosa, taking into account the ministerial handbook in which the wording slightly differs to that of the Code of Conduct. So all a bit confusing and a bit muddling, Sally, but the Public Protector not taking this one as a major slight, and saying in actual fact lessons are to be learned here in terms of how you interpret these codes of conduct that regulate how MPs and others disclose their financial interests. Here's an official from her office, the head of legal services, in conversation with Clement earlier today.
The Constitutional Court is entitled to criticize the Public Protector in the manner that they deem fit. But what happened here is that actually the Public Protector did not change the wording of the code. There is two codes that regulate the executive members' conduct. And one code is contained in the Ministerial Handbook, and it was approved by Cabinet in 2007. That is the code that contains the words inadvertently and deliberately. And that is the very same code that the former Public Protector relied on in her investigation in the Nkandla judgment. It's the very same code that was relied on when the former Minister Dinapule was investigated by the former PP. So it cannot be that the Public Protector went out of her way to create words that are non-existent in statute. She relied on the code that is there, that was approved by the Cabinet in 2007. Now you have a code that is promulgated in 2000 that has the words willfully, and the two codes are actually the law because they guide the members of the executive in how they conduct their affairs. And the Public Protector relied on the code of 2007, which was relied on actually by the same Constitutional Court in the Nkandla judgment.
Well, I suppose, Lindsay, and I have had a little look at the judgment, but I'm no legal expert, but the legal experts at the Constitutional Court must have considered all those versions and also the version that she presented them with in making this decision on whether she had erred or not. But nevertheless, a very interesting day by all accounts, and thank you so much for bringing us those reactions to the latest developments from the Constitutional Court.